6. Usury. Few laws are more misunderstood than the usury laws of the Bible. The word usury itself confuses the issue. It does not refer to exorbitant interest in biblical usage, but to any interest at all. To avoid misunderstanding at this point, the American Revised Version of 1901 will be used. The law reads as follows: If thou lend money to any of my people with thee that is poor, thou shalt not be to him as a creditor, neither shall ye lay upon him interest. If thou at all take thy neighbour's garment to pledge, thou shalt restore it unto him before the sun goeth down. For that is his only covering, it is his garment for his skin. Wherein shall he sleep? And it shall come to pass, when he crieth unto me, that I will hear, for I am gracious. Exodus chapter 22, verses 25 to 27. And if thy brother be waxed poor, and his hand fail with thee, then thou shalt uphold him. As a stranger and a sojourner shall he live with thee. Take thou no interest of him or increase, but fear thy God, that thy brother may live with thee. Thou shalt not give him thy money upon interest, nor give him thy victuals for increase. I am Jehovah your God, who brought you forth out of the land of Egypt, to give you the land of Canaan, and to be your God. Leviticus chapter 25, verses 35 to 38. Thou shalt not lend upon interest to thy brother, interest of money, interest of victuals, interest of anything that is lent upon interest. Unto a foreigner thou mayest lend upon interest, but unto thy brother thou shalt not lend upon interest, that Jehovah thy God may bless thee in all that thou puttest thy hand unto, in the land whither thou goest in to possess it. Deuteronomy chapter 23, verses 19 and 20. First of all, in 2 of the 3 statements of this law, it is specifically stated that the law has reference to the poor, and, moreover, to poor fellow believers or covenant members. Deuteronomy is, in part, a summary of the law and apparently assumes the same fact. This point is very important in that much of the misunderstanding of this law stems from misconstructions of the word brother. For centuries, the Church assumed that brother referred to every believer, and it accordingly banned all interest among Christians. The Talmud followed a similar interpretation. All interest payments between the Israelites were forbidden. However, a variety of evasions arose, and it became the practice for an Israelite to ascribe his money to a Gentile, and he lends it to an Israelite on interest. A number of technicalities were also developed, whereby interest could be exacted without being regarded as interest. The same was true of medieval theory and practice. Calvin altered this brotherhood thesis. In Nelson's curious terminology, he charted the path to the worlds of universal otherhood, where all became brothers in being equally others. Nelson's conclusion is highly questionable. Calvin clearly recognized that the law did not abolish interest, but rather called for help to the deserving poor brother. In commenting on Exodus chapter 22, verse 25, Calvin stated, "The question here is not as to usury, as some have falsely thought, as if he commanded us to lend gratuitously, and without any hope of gain, but since in lending private advantage is most generally sought, and therefore we neglect the poor and only lend our money to the rich, from whom we expect some compensation. Christ reminds us that if we seek to acquire the favour of the rich, we afford in this way no proof of our charity or mercy, and hence he proposes another sort of liberality, which is plainly gratuitous, in giving assistance to the poor, not only because our loan is a perilous one, but because they cannot make a return in kind. The point Calvin then made boldly, breaking with the entire tradition stemming from Aristotle, which held all interest to be an evil, was that interest is not in itself evil. Calvin had no liking for interest or for money lending. He was conscious of the weight of prejudice against it, and he stated that he would prefer a world without it. But I do not dare to pronounce upon so important a point more than God's words convey. I have, then, admonished men that the fact itself is simply to be considered, that all unjust gains are ever displeasing to God, whatever colour we endeavour to give it. But if we would form an equitable judgment, reason does not suffer us to admit that all usury is to be condemned without exception. If the debtor have protracted the time by false pretences to the loss and inconvenience of his creditor, will it be consistent that he should reap advantage from his bad faith and broken promises? Certainly no one, I think, will deny that usury ought to be paid to the creditor in addition to the principal to compensate his loss. If any rich and moneyed man, wishing to buy a piece of land, should borrow some part of the sum required of another, may not he who lends the money receive some part of the revenues of the farm until the principal shall be repaid? Many such cases daily occur in which, as far as equity is concerned, usury is no worse than purchase. Nor will that subtle argument of Aristotle avail, that usury is unnatural, because money is barren and does not beget money. For such a cheat as I have spoken of might make much profit by trading with another man's money, and the purchaser of the farm might, in the meantime, reap and gather his vintage. But those who think differently may object that we must abide by God's judgment when he generally prohibits all usury to his people. I reply that the question is only as to the poor, and consequently, if we have to do with the rich, that usury is freely permitted, because the lawgiver, in alluding to one thing, seems not to condemn another, concerning which he is silent. The total condemnation of interest has led to very ugly moral consequences. Moneylenders and bankers have, as a class, been regarded with distrust because of the lingering condemnation of usury. From the medieval period, such persons were seen as a kind of evil conspiracy against mankind, and this opinion has grown instead of subsiding. We are continually told by both conservatives and socialists that international bankers and the money trust are in conspiracy against mankind. Although no evidence for this is ever presented, the fable has been so often repeated that it is assumed to be true because so many people believe it. The 16th century Dean of Durham, the Reverend Dr. Thomas Wilson, a vigorous enemy of all interest, clearly revealed the moral confusion this position leads to. In describing the wickedness of moneylenders, Wilson cited an example. I know a gentleman born to £500 land, and entering into usury upon pawn of his land, did never receive above £1,000 of net money, and within certain years runnage still upon usury, and double usury, the merchants terming it usance and double usance by a more cleanly name. He did owe to master usurer £5,000 at the last, borrowing but £1,000 at first, so that his land was clean gone, being £500 inheritance for £1,000 in money, and the usury of the same money for so few years, and the man now beggeth. I will not say but this gentleman was an unthrift divers ways in good cheer, may in evil cheer I may call it, in wearing gay and costly apparel, in roystering with many servants more than needed, and with mustering in monstrous great hose, cards and dice, as time served. And yet I do say, he lost more by the usurer than he did by all those unthrifty means. For his vain expenses was not much more than £1,000, because he had no more, whereas the usurer had not only his £1,000 again, but 4 times more, which is £5,000 in the whole, and for want of this payment, the £500 land was wholly his. And this gain only for time. The heir in question spent all the income from his estate plus his £1,000 loan in riotous living and ended a beggar. He spent more than the loan sum, therefore, and Wilson was thus in error here. The interest seems high, but here we cannot judge, because we do not know the years of this wayward heir's life. The 16th century saw much inflation in England. Interest rates during inflation climb proportionately, and interest figures are thus relative. The loan was probably a legitimate loan. Very clearly, the morality of the heir was bad. The evil in this case was very plainly mainly that of the heir, and possibly entirely his. Wilson gives no evidence of clear-cut wrongdoing on the part of the moneylender. Instead, his position is that money lending is in itself evil. As a result, he passes lightly over the obvious moral dereliction of the young gentleman, who deserved to be a beggar. This habit of condemning others for our own sins has become deeply ingrained in Western man as a result of his hostility to money lending. It has also been a fertile ground for anti-Semitism. Second, the nature of the loan to the poor deserves careful attention. According to Rushdoony, commenting on Exodus chapter 22, verses 25 to 27, the real point is that in his regulations with a poor man, possibly his own employee, an Israelite must be generous. If he gives him an advance payment on his wage, he must not insist on payment by the end of the day at the risk of the man's doing without the garment he has given as pledge for the loan. Verse 26. The original admonition was not so much a prohibition of interest as a demand that one be ready to risk an advance without material security. Amos chapter 2 verse 6 condemns Israelites for having treated such advances in a strictly legal manner, even at the cost of making the poor destitute. As a barter economy developed into a money economy, the problem of interest became increasingly acute. Deuteronomy chapter 23 verses 19 and 20, Leviticus chapter 25 verse 26. Between Israelites, interest on commercial loans was prohibited. In Hebrew, the word interest means bite. To take a neighbour's garment in pledge for any time longer than the working hours of the day when he does not wear it is equivalent to making him pledge his life. Compare Deuteronomy chapter 24, verses 6 and 17. This prohibition ultimately makes enslavement for debt impossible. Rushdoony's evolutionary faith leads him to assume a later date for the laws in Leviticus and Deuteronomy, and hence a different meaning. For this, there is no evidence. He is right, however, in citing this law as evidence of advance payment of wages. The pledge taken was of the outer garment or cloak in which the poor worker slept. The reference is to the poor people with the lender, to my people with thee that is poor, to people working on his land with him. The same meaning appears in Leviticus chapter 25, verses 35 to 38, and it is expanded. If a poor fellow believer, who is employed by the well-to-do believer, is in financial distress because of some crisis, he is to receive the same hospitality which a foreigner or a traveller would receive, the hospitality due to a visitor. The charity is thus to be gracious, and the loan without interest. Wright's comment on Deuteronomy chapter 23, verses 19 to 20, bears this out. No interest is to be charged on loans to a fellow Israelite, though it is permissible in the case of a foreigner. Since most loans in Israel were for the purpose of relieving distress, the principle behind the law was that another's need should not be the occasion for profit. The use of loans in international commerce was for another purpose. Hence, the foreigner is excluded from the requirement. It is commendable when a rich man lends to poor fellow believers, but this is an act of voluntary charity, whereas the law, as the wording of Leviticus makes clear, requires this charity as mandatory towards employees. No rich believer has the ability to lend to every needy fellow believer. He does have the ability to help those whom he employs. His responsibility here is to advance them loans without interest, against their wages, and to give emergency loans in times of crisis. The prohibition against interest is thus limited to a specific type of case, and it involves more than a mere prohibition, in that an active duty towards those under our authority is required. Third, while charity is clearly the purpose of this law, charity is not confused here with a gift, a loss, or foolishness. A pledge or security can be, although it need not be, required. As Gary North points out, this forbids fractional reserve banking, in that the security cannot be used to negotiate a second loan, in that it is held by the lender during the day. The pledge requirement was a protection against irresponsibility on the part of the poor worker. If the poor worker were a trustworthy man, the employer would not require the pledge. The pledge, or security, was thus insurance against failure to repay, or to work out the loan. The charity in this case is thus a gift of the interest, not of the loan. The indictments of usury in the prophets are indictments of loans to workmen at interest, to seize their small holdings of land. In Psalm 15 verse 5, such usury is coupled with taking. Reward against the innocent, that is, bribe-taking. In Proverbs chapter 28 verse 8, we are told that, He that augmenteth his substance by interest and increase, gathereth it for him that hath pity on the poor. That is, the man who charges interest to his poor employees who are believers will be judged finally by God, and his wealth given to those who take pity on their poor brethren. Jeremiah faced the hostility of men who enslaved their fellow believers rather than helping them. Jeremiah chapter 15 verse 10. Ezekiel referred to the same kind of oppression. Ezekiel chapter 18 verse 13, chapter 22 verse 12. Nehemiah required a return to the biblical law. Nehemiah chapter 5 verses 1 to 13. Jesus referred to the same kind of loan without interest in passing in Luke chapter 6, verses 34 and 35. His approval of interest on commercial loans is clearly apparent in Luke chapter 19, verse 23, and Matthew chapter 25, verse 27. Unger's summary statement is thus clearly in the main correct. The Israelites, not being commercial people, money was not often loaned for the purpose of business, but rather to aid the struggling poor. This last is the only kind of interest forbidden in the law, and the avoiding of this is sometimes given among the characteristics of the godly man. Psalm 15, verse 5, Jeremiah chapter 15, verse 10, compare Proverbs chapter 28, verse 8. The practice of mortgaging lands, sometimes at exorbitant interest, grew up among the Jews during the captivity, in direct violation of the law. Leviticus chapter 25, verse 36, Ezekiel chapter 18, verse 8, and verse 13, verse 17. And Nehemiah exacted an oath to ensure its discontinuance. Nehemiah chapter 5, verses 3 to 13. Jesus denounced all extortion and promulgated a new law of love and forbearance. Luke chapter 6, verses 30 and 35. The taking of usury in the sense of a reasonable rate of interest for the use of money employed in trade is different, and is nowhere forbidden, and is referred to in the New Testament as a perfectly understood and allowable practice. Matthew chapter 25, verse 27, Luke chapter 19, verse 23. There is no ground for calling our Lord's statements a new law of love and forbearance, when it is no more than a summation of the law of the Old Testament. Fourth, while interest is permitted on commercial loans, all such loans are under the restriction of the Sabbath law, that is, their life is limited to 6 years. According to Deuteronomy chapter 15, verses 1 to 6. At the end of every 7 years thou shalt make a release, and this is the manner of the release. Every creditor shall release that which he hath lent unto his neighbour. He shall not exact it of his neighbour and his brother, because Jehovah's release hath been proclaimed. Of a foreigner thou mayest exact it, but whatsoever of thine is with thy brother, thy hand shall release. Howbeit, there shall be no poor with thee, for Jehovah will surely bless thee in the land which Jehovah thy God giveth thee for an inheritance to possess it. If only thou diligently hearken unto the voice of Jehovah thy God, to observe to do all this commandment which I command thee this day. For Jehovah thy God will bless thee, as he promised thee, and thou shalt rule over many nations, but they shall not rule over thee. Short-term loans are alone permitted. No godly man has the right to mortgage his future indefinitely. His life belongs to God and cannot be forfeited to men. Thus, every kind of debt by believers, whether as charity or for business reasons, must be a short-term debt. The Sabbath is basically and essentially rest rather than worship, and basic to the Sabbath rest is debt-free living. Long-term debts are clearly a violation of the Sabbath, and many churches that profess to be devout Sabbath keepers are flagrant Sabbath breakers here. The normal life of the covenant man is to be debt-free, to owe no man anything save the obligation of rendering tribute, honour, fear, and custom wherever due, and of rendering that love which is the fulfilling of the law. Romans chapter 13, verses 7 and 8. If this and all other laws of God be kept, there will be no poor among the people of God. This is a firm and unqualified statement. It presupposes that the godly man can keep the law to that degree necessary to receive this blessing. Fifth, the unbelieving are excluded from the charity required by this law, both the interest-free loans and the termination of the debt in the sabbatical year. The ungodly are already slaves to sin by nature. The true slave cannot be weaned from slavery, and it is foolishness to treat him as a freeman. The godly are freemen by nature. In times of distress, they need relief to regain their freedom. Freedom cannot be given to a man who loves slavery, and it is foolishness to attempt it by means of money. Regeneration is his only solution. Sixth, on citing their deliverance from Egypt, God reminds his people that the purpose of his law is to deliver man into freedom, even as he delivered them from slavery to freedom. The purpose of the law's governing interest and the purpose of the whole law is man's freedom under God. To speak of deliverance from the law is to speak of deliverance from freedom. The law cannot be freedom to the sinner, but rather a sentence of death for his failure to keep it. The lawbreaker is a man in slavery to his sin, a man unable to live in terms of freedom. The law, therefore, is a continual indictment and a death sentence to him, in that it underscores his impotence and his inability to rule himself. What I hate, that I do. Romans chapter 7, verse 15. To the redeemed, however, the law is a way of freedom. Seventh, the pledge was, as we have seen, a pawn or deposit as security for a debt. Certain kinds of pledges were forbidden. No man shall take the nether or the upper millstone to pledge, for he taketh a man's life to pledge. Deuteronomy chapter 24, verse 6. Thou shalt not wrest the justice due to the sojourner, or to the fatherless, nor take the widow's raiment to pledge. But thou shalt remember that thou wast a bondman in Egypt, and Jehovah thy God redeemed thee thence. Therefore I command thee to do this thing. Deuteronomy chapter 24, verses 17 and 18. When thou dost lend thy neighbour any manner of loan, thou shalt not go into his house to fetch his pledge. Thou shalt stand without, and the man to whom thou dost lend shall bring forth the pledge without unto thee. And if he be a poor man, thou shalt not sleep with his pledge. Thou shalt surely restore to him the pledge when the sun goeth down, that he may sleep in his garment and bless thee. And it shall be righteousness unto thee before Jehovah thy God. Deuteronomy chapter 24, verses 10 to 13. That the reference in Deuteronomy chapter 24, verses 10 to 13 is essentially to workers serving a wealthy fellow believer appears in the passage immediately following. Deuteronomy chapter 24, verses 14 to 16. A pawn or pledge cannot involve anything necessary to a man's work or living, for to do so would be to endanger the man's life, that is, his freedom. Moreover, the dignity of the borrower cannot be broken or harmed. The widow's raiment cannot be taken from her, nor can a creditor enter a man's home to choose the pawn or pledge. Even a poor man's home has a sanctity which a creditor cannot challenge. A man's house is his castle. The source of this principle is Deuteronomy chapter 24, verses 10 to 13. The dignity of the borrower cannot be infringed by the man making the loan, whether with or without interest. The horror for degrading pawns is expressed in Job chapter 24, verses 9 and 10. There is, however, an analogous obligation on the part of the borrower. No man has the right to risk those things which are basic to his life and liberty, nor to borrow on those things, even if someone is ready to make the loan. The cloak of the poor workman, his sleeping garment, is as much as a man can pledge, and even then only for the daytime hours. The widow's cloak cannot be pledged. 8th, failure to restore a pledge or pawn when repayment is made is robbery, and it is linked to pagan worship, adultery, theft, and murder, as is also exacting usury of a poor fellow believer. This appears clearly in Ezekiel chapter 18, verses 10 to 13. If he beget a son that is a robber, a shedder of blood, and that doeth any one of these things, and that doeth not any of these duties, but even hath eaten upon the mountains, and defiled his neighbour's wife, hath wronged the poor and needy, hath taken by robbery, hath not restored the pledge, and hath lifted up his eyes to the idols, hath committed abomination, hath given forth upon interest, and hath taken increase, shall he then live? He shall not live. He hath done all these abominations. He shall surely die. His blood shall be upon him. Ezekiel had in mind here the coming fall of Jerusalem, but he still cited God's basic judgment on all who fail to restore a pawn. The law here has been subjected to extensive attack by socialism and every form of totalitarianism. Statism assumes that its law, rather than God's regenerating power, is the principle of freedom. As a result, it legislates against biblical law. Modern, quote, civil liberty, end quotes, and, quote, civil rights, end quote, legislation requires an equalizing of all men, so that an employer cannot hire or favour his fellow believers in distinction from unbelievers. The end result is the enslavement to the state of all men. The need for charity remains, but the state now makes itself the source of charity and the judge as to who shall receive it. An impersonal and political test replaces the test of faith.